provides that under compelling circumstances, if there are compelling circumstances which are reasonable, a person can be detained for more than 24 hours. And Your Honor, I wish to humbly submit that in our case, may the court find that we have expressed sufficient ground and reason to have the accused detained beyond the 24-hour rule in order to enable investigations herein conclude. My learned colleague here submitted that the issue of processing a clip of the incident and having the same ready for purpose of hearing of this case. He alluded that that is something which can be done in 2 or 5 minutes. Your Honor, that is something which involves a complex process, which in all fairness cannot take 2 to 5 minutes. Now, coming to Professor Ngugi's authority, which has been highlighted by my learned colleagues, I appreciate the authority insofar as the authority is concerned, and what is contained therein is something which ought to be appreciated. But even so, this honorable court will have to take into account.
Objection, Your Honor. You can't comment on an authority. More so from the learned Professor Ngugi and the High Court of Kenya.
Your Honor, I'm not discrediting the authority. I'm not discrediting the authority.
How exactly are you objecting? What is your
Yes, Your Honor, he's trying to air his comments on the authority to water down the authority, an authority which binds all of us.
But you lay bare the authority to
why you are here?
the
You
court.
said, I've not even gotten the objection. So can you just tell me why you're objecting to it, and then you let him respond?
The objection manifests itself in this form. It's an authority by the High Court of Kenya, which seeks to bind all of us, myself included. My colleague and senior is trying to water down the authority by airing his comments and discrediting the authority.
Just a minute. Where exactly did he water it down?
He wants to make a comment, Your Honor, over the said authority.
Your Honor, you need to comment
Just a
on it.
minute.
Yes, Your Honor, what I wish to say, I was asking, but in fact I was not discrediting the authority of our senior learned professor. There is something very critical that I wanted to highlight, to bring to the attention of the court in respect to the authority. Because these authorities are not authorities are not produced to the court in vain. They must be read through. They must be commented upon. They must be compared with like authorities, either in the High Court or from the Court of Appeal. So it is unrealistic for my learned friend to allude that I have no right to comment on this authority that he has tendered to the court. As a matter of right and in argument of our case, I have a legal right to comment over it. and that's a right which is unlimited. A right to comment on an authority which has been produced to the court by the adverse party is not a right which is limited. So I wanted to ask the Honorable question.
Mr. Sergon. Mr. Sergon?
Yes, Your Honor.
Your response? Any?
My response, I'm waiting for it to water down the authority.
I'm concluding. I'm not watering down the authority. Your Honor, it is not my responsibility to water down authorities which have been rendered by respective courts. They must be respected, but they must be commented upon. So my Lord, Your Honor, I wish to Your Honor, can I make my last point on that one?
Kabarnet?
Mr. Blood, Your Honor.
So, Your Honor, I wish to ask the court to make a finding that owing to the facts and circumstances of this case,
I wanted to see what was the authority.
on the authority. I wanted to point out, I'm not discrediting the authority as my learned colleague is putting it, because I'm someone who embraces quite a lot of professionals.
Proceed and make use of
So what I'm saying, is that the Honorable Court will have to consider the facts and circumstances of that case by Professor Ngugi. In other words, what were the facts and circumstances of that case as compared? The facts and circumstances of that case as compared to this case. And then when the court does that, it will come to a finding that that case is most likely distinguishable from the current case that we have. It is quite probable that in Professor Ngugi's case, there were no compelling reasons to detain the accused persons for a longer time than the laws and delays. But in light of the facts and circumstances that we have enlisted to this court, may this Honorable Court make a finding that we have at least sufficient reason, and we have enlisted compelling grounds sufficient to warrant this Honorable Court to grant our application. Your Honor, that's all. It's nothing.
unhappy, because she was unwell. She set an application to make. When Mheshimiwa has serious ulcers and she has some support chest pains, she was under medication before she was treated from Nairobi. When we agreed that she should come to hospital, preferably Jematia Hospital, because she's enjoying Kabarnet medical care. It's the only hospital there which can enjoy using her.
Be taken for treatment?
Most of it. Which is what?
I did specify.
It's better you're the order to be clear because we know the problem we have with the authority.
How am I supposed to know if the police are capable of escorting her to a private hospital under security reason? So they will be able to assess where is it safe. All you want is for her to be treated, right?
Yes.
She'll be taken to a facility where she's going to be treated. Can I find a place to pass?
Thank you, most of that.
Hello,